We've recently reported on residents being forced to leave their homes due to unsafe conditions. So we wanted to know, what are the legal options for a tenant who gets an evacuation notice? We went to a local expert who spoke specifically about Miami-Dade County's ordinance on this issue.
The building officials have determined that the tenants have to vacate for safety reasons, and they force the tenants out of the unit. The owner of the property is responsible because the unsafe conditions are a result of the owner's negligence. The owner has to make arrangements for those tenants for temporary housing within 8 hours of the requirement to vacate. The owner has to provide temporary housing for at least 3 months or until the property is made safe and the tenants are allowed to return, whatever happens sooner. In situations in which the owner does not meet those obligations, the ordinance says that the county can provide emergency housing and meals for 7 days, and that the county can provide financial assistance for up to 3 months of rent. And then the county has the power to go back and try to claw back whatever they spent from the owner.
We must add that the Miami-Dade County ordinance that Salazar just explained is complicated due to the legislation Florida passed in July, which strips municipalities from the ability to enact local tenant protections. Salazar says House Bill 1417, known as the Preemption Bill, preempts local tenant rights ordinances, and it says that there will be only one uniform law across the state.
Our position at Legal Services is that this particular ordinance should still be in effect, specifically because it appears in the section of the ordinance that relates to building codes and safety, and not in the section that relates to the Tenants' Bill of Rights.
We also asked Salazar if lease agreements usually address forced evacuations.
I don't think it's very common for the lease to say that if the government shuts the building down, then this is what will happen. I haven't seen that personally. Leases sometimes do say that if the unit becomes unlivable for whatever reason, it may have certain things in there. It may say that the rent will be abated for a certain period, something like that. But you'd have to read the particular terms of your lease.
Sometimes in these situations, some tenants would rather move out than wait for management to fix things. But would they be allowed to break leases in that case?
You'd have to look at the specific terms of your lease. But I can just tell you, generally under landlord-tenant law, if you are in a situation where there's bad conditions in your unit, the applicable statute is Florida Statute 8351 and Florida Statutes 83.60. And those kind of lay out what the landlord's obligations are to maintain the unit. In this case, we're talking about the landlord's obligation to maintain that unit that you're living in, but not the structural integrity of the building, which would be the responsibility of the condo association. But if I'm just a regular tenant and I'm renting a unit and my landlord refuses to make repairs to my unit, and these are things that the landlord is responsible for repairing under the lease, then what I'm supposed to do under these statutes is I'm supposed to send what's called a 7-day rent withholding letter or a 7-day letter terminating the tenancy. And you have to send that at least 7 days before the rent is due. And you can say, if you don't make these repairs within 7 days, then either A, I'm going to be moving out, or B, I am going to withhold the rent that comes due the following month.